think I'd got to the point where about to look at some of the where the original paper started, I think, which is drafting settlement agreements. Page 12 of the paper. Now, I don't profess to be any sort of authority on all the terms that one finds in settlement agreements, but it is useful to compile a bit of a checklist. Again, like you do with your call bank offers, a number of dot points that you go through. Perhaps you take them with you to a mediation. You have a little kit bag full of a few of your precedents, because there's always something. You know, I know GST is a live issue in lots of settlements. So one needs to not just have a GST clause, but I think you just need to be aware of the ATO ruling about GST. That forms part of your toolkit. I think as there's such a range of settlements, many are quite simple, where it's payment of money between a couple of parties, not particularly difficult to draft, but many commercial disputes become quite complex, and in those cases, the situation I struck during the 90s when there were lots of these bank workouts, one I can recall, there was a collapse of a major retail chain with a large number of leases of stores throughout Australia. It had creditors ranging from lessors, suppliers, equipment financiers and banks. And I recall we all met in this auditorium addressed by David Crawford, who in those days was the insolvency guru. And it was, I guess, a compliment to his ability as a negotiator. He managed to get the heads of agreement down to 12 points, which everybody signed off on that at about 11 o'clock that night. And we thought, oh, fantastic, we've got a deal. Well, we had a deal, but it then took about 4 weeks for that 12-point heads of agreement to be put into something like about a 40-page document with various annexures and schedules. It still worked. I think the genius of Crawford was that he managed to get it all into the 12 points and had people sign off so that they really couldn't back out of it. But the putting the flesh on the bones was the complexity, and it was ultimately achieved, but after a lot of hard work. Now, if one does that, I call that the two-stage approach. That is, that you have an HOA or a memo of settlements, and then you have to work it out. The complexity works out with a more detailed agreement. The two-stage approach runs into typical sort of Masters and Cameron type problems. Is it an agreement to agree, or is it an agreement, the terms of which they are going to be put together? It's binding, and nonetheless it's going to be put together by the lawyers over the next few days, that sort of arrangement. Now, I think we're all familiar with the Masters and Cameron categories, so I won't bore you with them. They had a recent rerun in the ASIC litigation against Fortescue Metals. I think it was Chief Justice Keane of the Federal Court who did a very detailed analysis of whether, excuse me, whether the so-called agreements with the Chinese parties to build the infrastructure for the Fortescue mine were sufficiently binding for Fortescue not to mislead the market by saying it had its agreements in place for the development of the mine and the railway and all the infrastructure. His Honour held not. Now, I think the case is probably going to the High Court, but I think there's a special leave application. I'm not sure where it is at the moment, but notwithstanding that, Chief Justice Keene's decision is well worth having a look at if you're in that area of, you know, is it a Masters and Cameron type problem? Now I then go into some drafting considerations. I make the observation I made at the outset that talking to lawyers about legal drafting is perhaps one of the most challenging things you can do. I mean, we all have our strengths and weaknesses with drafting. I think we can all learn from each other all the time. I never cease to be amazed at the ability and ingenuity of fellow lawyers when I come to sitting down to negotiating and settling terms of settlement. So that I think we should just keep that in mind, that there's no one way of doing these things and we can always learn how to improve. I've just set out a few principles there though. The first one, I think, which comes out of the earlier discussion about accord and satisfaction and covenants not to sue and so forth. How is the agreement to operate? Is it going to dispose of the dispute, or is it going to operate as in other words, as an accord and satisfaction, or are there conditions to be satisfied before it operates as an accord and satisfaction? The next point, I guess, is before your client signs up, have you really fully considered their prospects in the proceeding, if it is a proceeding on foot? Is it an appropriate settlement for them to enter into? You need to spend that time taking them aside. At that point when in the mediation we all experience where the clients turn to you in the private session and say, well, what do you think, Mr. Bailey? Should we accept this offer? Is it a good offer? Then you've really got to say, well, on the face of things, it's the best we're going to get today. Let's now look at whether we should accept or walk away and come back another day. One of those moments as a practitioner where you think, goodness, if we walk away, will we get another offer? I well remember one Christmas Eve where I sat down with a client who was having a major dispute with a big public company about whether they'd do a deal, and there was a sticking point. I was acting for a very, very small company, not a lot of clout. What we didn't know was that the public company desperately needed this deal. And I was a fairly young solicitor at the time. My client said to me, well, what should we do? And I took a deep breath and said, well, I think we should just tell them to improve their offer. That 2 weeks over the Christmas break before we got the other offer just about killed me. I think I thought, has it gone away? Have I completely stuffed this up, or are we going to get an offer? We got another offer, thank goodness. But it's one of those moments in your life as a lawyer where you've just got to take when you fully inform your client, and they must be part of that decision, obviously, but it's one of those moments that you do have to just test whether that is the appropriate settlement for your client. A few other points there, how the releases should work. And one thing to be very careful of is that the release is not drawn too widely, but just be drawn to suit the requirements of the particular case or situation. Sometimes there may be parts of the dispute, particularly where you've got clients from a different cultural background, where it's not just money or resolving the technicalities of the dispute. There may be some loss of face or intangible, which is very important to the client, and you need to be able to try and cater for it. It might simply be that they want to make a statement in their community that there's been a satisfactory resolution of their dispute, so you agree on some wording that the parties can use to convey that. Seems a simple sort of thing, but it may be very important. Obviously, the use of plain and unambiguous language is very important, and the point that Paul made at the outset too, good drafting takes thought and time, and if you need to hesitate, don't feel embarrassed or under any pressure if you need to take time. Too many good settlements are spoilt by rushing the last part of it. I've given you a checklist there, which I won't go through. I like checklists, even though we shouldn't be governed by them, but we should use them just as a aid memoir. Question that sometimes arises is, should the settlement be under seal or not? And the case I referred to before in Western Australia, Scafidi and Perpetual Trustees, contains a very useful analysis of the way releases work at common law, and I've set them out in some detail. See there that at common law, a release had to be a discharge under seal of an existing obligation or a right of action. However, as an alternative, it could also be released by an agreement for valuable consideration, so long as it amounted to an accord and satisfaction. There's a bit of the old learning there. And a release by deed and a release by accord and satisfaction therefore extinguishes the original obligation. Perhaps the fly in the ointment at common law was that if the original obligation was by deed, the release had to be by deed and not by an accord and satisfaction. Okay, so that's all sounds fairly arcane. Equity, as equity was wont to do, stepped in and made up for some of the common law issues by enforcing agreements for value to release an obligation, whether it was created by deed or not, so that equity in effect reduced the need, I think, to use deeds as a matter of course. Now, the other point which is important, and that is that a covenant not to sue, unlimited in time and general and unconditional, can be pleaded at common law in bar, even if not under seal. Okay, now the final point that might have some relevance as to whether you would use a deed is that an agreement under deed becomes a specialty as regards statutes of limitation, and you may have a longer limitation period to think about as being worthwhile. So I guess the conclusion I reach is that the formality of a deed is not ordinarily necessary, but in practice it's usually adopted, especially if the terms of settlement are complex or there's some doubt about consideration or enforceability as a simple contract. Which leads comfortably into the next topic, which is enforcing settlement agreements. And this is a very fruitful area for disputes. And also, I think just puts the focus on the need to try and make your agreement bulletproof. There are, of course, many cases where the terms are self-executing, such as if there's a default in payment, the plaintiff can enter judgment, and the judgment can be entered by producing the terms of settlement with an affidavit to the effect that the terms have not been met. The other way of doing it that came out of the common law was that so long as the original proceeding was still on foot and you had terms of settlement which were conditional, you could enforce the terms of settlement in the proceeding. The famous exposition of this principle is in the case of Roberts and Gippsland Agricultural and Earth Moving Contracting Co., which was a decision, or I think the leading decision was of Justice Smith, not the recently retired Justice Smith, but that Justice Smith's father, who was both very good judges, but I think the father wrote some brilliant judgments, and this is one of them. It was a simple case of a monetary claim where there'd been a compromise and the defendant was to pay a sum certain in full settlement. There was a failure to pay, and the plaintiff brought on a motion to enforce the terms of settlement. And then there followed the discussion by the full court of the Supreme Court of Victoria, and I've actually got the quotation from Justices Lowe and O'Brien, which I've set out there on page 18. I won't read it out. But it was Justice Smith who actually went through a more detailed exposition of the origin of the principle and its application. And this is why he makes the point it's very important to not have the proceeding discontinued. Now, that's why the famous mantra of struck out with a right of reinstatement is important. Because what that means is that the case is not removed from the court's register, it's simply removed from the list of cases, pardon me, awaiting trial. So it's taken out of the list, but it's actually still there as a live case, perhaps as a dormant case might be the way to describe it, so that it can be revived if the terms of settlement aren't carried out. Now, Robert's case is a long time ago, 1956, but it's still frequently applied, and I've given you a couple of examples. The Federal Court, there's a Zippo Manufacturing Company against Jack's Lawn, which was about, I think, a dispute about cigarette lighters and trademarks. And in fact, it's the terms involved quite complex dealings with a whole series of trademarks, but the Federal Court was able to give effect to those terms. I think one clear reason is that they were very carefully set out, and all the trademarks that were affected were carefully schedulised and defined, so that the court didn't have any concern about that. I make that point because, as Justice Smith said in the old Roberts case, the principle is unexceptional, but it will not be applied where the court has to get involved in matters extraneous to the action itself. Now, what do I mean by that? There's a recent illustration in the case of Sea Change Management and Pital Business in the Court of Appeal in Victoria. There was a joint venture dispute which was settled on terms providing for payments by Sea Change in exchange for another company surrendering interests in certain partnerships and giving warranties of title. Well, Sea Change defaulted in its payments, and the other party sought to enforce the terms. And the enforcement was opposed on the basis that the settlement involved complex and extraneous matters, such that the court ought not to apply the Roberts principle. And in fact, that's what happened. The Court of Appeal examined the limits of the Roberts case and made the following statement, and it is worth focusing on this. In summary, therefore, the net effect of the authorities to this point seems to be that although the power summarily to enforce a compromise is discretionary and is wider now than once was the case, it is not to be invoked unless the court is clearly satisfied justice can be done. And whether justice can be done is a question of degree. Consistently with the equitable rights of the power, one must weigh among other competing considerations the extent to which enforcement would involve extraneous matters, how substantial a question to be determined as a precursor to enforcement may be, and procedural considerations like the desirability of pleadings and discovery and additional cross-examination. And that's what troubled the court in that case, that it was unable to go into all those sorts of considerations where you had a complex settlement. Now, there's another spin on this enforcement in the proceeding by the court. What happens if the agreement involves a party that's not before the court? Now, it seems clear enough that the non-party can't enforce the terms because they're not a party to the proceeding, but is the presence of the non-party enough to deny one of the parties access to the court to enforce the agreement? Now, that question arose in A.G. Cowley and Central City case before the Federal Court. And the court made plain that the non-party couldn't invoke the jurisdiction, but the other parties could. The reasoning of Justice Barker was that the obligations between the parties were independent of the obligation of the non-party and stood capable of enforcement. but His Honour also made the observation that if you need to enforce the terms against the non-party, a separate proceeding would have to be instituted. So it's not without some complexity, but the fact you've got a non-party in there doing something doesn't deny the parties the ability to go to the court if their compact can be enforced.
Did the non-parties sign the document?
Yes, I think so. As far as I know, it was a mediation. So it's yet another bell and whistle in this whole area. Pardon me. And I guess, of course, the practicality of that situation is that if you've got a non-party that has to be involved, you're not going to. You want to do the deal rather than worry about whether you can enforce in that proceeding or not. You'd rather get the deal in some enforceable way than not at all, I'd imagine. Now, the last, I think it's the last, maybe it's not the last bit, second last bit is setting aside settlement agreements, which I referred to before in the case of National Australia Bank and Collar. Another checklist for you is I've set out the grounds on which you might be able to set aside terms of settlement or a deed of settlement. And again, you go back to the law of contract, matters like duress, mistake, fraud and bad faith, failure of consideration, impossibility of performance, compromise reached without authority or by mistake. And as barristers and solicitors, I guess we get a little bit concerned about that because we have implied authority by virtue of our position representing our clients to undertake settlements on their behalf. So if I, as a barrister, sign up terms of settlement at the door of the court with a fellow barrister and my authority is later disputed by my client, then I've got to make damn sure that I had the authority and I can, I'm not at risk against my own client. There's quite a bit of law about that, but it's just part of our office and what we do, that we have that implied authority. Now, Civil Procedure Act starts to loom large in these things as well, and recently Justice Sifris was asked in a case where a multi-party dispute was going on and there were terms of settlement between some of the parties and not the remainder, and there was a provision which was attacked by the other parties in the course of the proceeding as contrary to public policy, as interfering with the administration of justice. The reason was this, that the term which was in question was in these terms: each and all of the Equinox parties agree and warrant they will not act against the interests of AED Services, Puffin IS or David Dix or any other director, officer or employee of AED, save as compelled by a court of Australia. Now, two parties that were bound by this provision were served with a subpoena, and an originating motion was brought seeking declarations that the clause didn't prevent them from conferring and communicating with the solicitors acting for another party. The application was necessary because of that term, but it was conceded the service of the subpoenas alone wouldn't breach the settlement deed, obviously because it's a process of law. What they're trying to do is to say, well, look, you can't confer if you're prevented from conferring. Sorry, I got round the wrong way. If you're prevented from conferring with the solicitors, then that's a breach of public policy. Well, Justice Sifris wasn't attracted to that idea. He said the term prevented the communication between the solicitors and the affected parties, but it didn't interfere with the conduct of the proceeding. In other words, the affected parties weren't prevented thereby from giving evidence in the proceeding. They might have been prevented from conferring, but that was a different thing. So you can see that the use of the Civil Procedure Act may be to attack settlements that perhaps overreach what might happen. In that case, Justice Sifris said, well, there wasn't an overreaching. which affected the administration of justice or tainted the procedures under the Civil Procedure Act or the objectives of the Civil Procedure Act. But one needs, again, to bear that in mind. Now, the last topic that I turn to is another. Most of these things could be papers in themselves, and I apologise for perhaps dashing through them. I've already had one person approach me in the break to say, look, you've just whetted the appetite with the proportionate liability, but you haven't really dealt with it. And I said, yes, I ducked that one, but it is a huge issue for settlements with multi-parties. And again, this next topic I turn to, which is loss of settlement privilege in negotiations, as a huge issue, and it arises in several ways. These days, of course, with the Evidence Act 2008, or in the federal sphere, the 1995 Commonwealth Act, the exceptions to settlement privilege are set out in statute. They do mirror to some extent the common law exceptions to the old or without prejudice privilege. There are two recent judicial expositions which are worth looking at. One is the English courts in the Unilever case, where that case was concerned a sort of unconscientious use of tactics in a negotiation, where what happened there was a party had overstated its position, almost like a Section 52 type case. The terminology was using, well, I said it out there, perhaps I haven't, I can't remember, but it was similar to that. It was a use of a misstatement in effect to achieve a result in a settlement, and the court said, well, that's not covered by the cloak of without prejudice privilege. If you start using tactics which border on deception, then and later on that deception is found out, of course the other party can try and set aside the settlement and prove that, because it's not protected by the privilege. And it's recently been reaffirmed in the Ocean Bulk case, which went to the UK Supreme Court, which for old coots like me is now the successor to the House of Lords. So I have to keep reminding myself of that. So it's got that high authority. And Lord Clark, who gave the majority decision in that case, said, I can see no reason why the ordinary principles governing interpretation of a settlement agreement should be any different, regardless of whether the negotiations leading to it were without prejudice. The language should be construed in the same way, and the question posed by Lord Hoffman should be the same, namely, what a reasonable person having all the background knowledge which would have been available to the parties would have understood them to be, using the language in the contract to mean. That background knowledge may well include objective facts communicated by one party to the other in the course of the negotiations. Now, the dispute circled round a term called sleeving, which was I think a maritime trade term. Now, one party said, well, no, you can't introduce evidence of that because it was part and parcel of the negotiations. And the court says, well, no, you're not, the without prejudice rule doesn't operate as a clamp on working out the meaning of what the settlement was. And to do that, you've got to go dig into any background knowledge about what sleeving meant. Now, I mention that case because Justice Lander in the federal court has recently made slightly critical comment about it on the basis he thinks that the UK Supreme Court perhaps overstated the principle. The case that Justice Lander was in was called Pahiga and Roach, decision last year of the federal court, and the question there arose as to whether evidence could be led as to false, misleading and deceptive representations in proceedings to rescind settlement. An application was made to set the deed of settlement aside as void ab initio, whereas some of the other parties countered by seeking specific performance. And the respondents who were seeking specific performance sought to restrain the use of evidence about the alleged misleading and deceptive conduct which led to the settlement. So Justice Lander had to review all the authorities dealing with the exceptions to the without prejudice privilege, and he held that 3 exceptions were applicable. The first one is, he said, you could give evidence of negotiations to show that that conduct occurred during the negotiations that would lead to the agreement being set aside, such as misrepresentation, fraud or undue influence. I think that seems clear enough. The second that he referred to was that even if there's a concluded compromise, a clear statement made by a party and on which the other party relies may be admissible as giving rise to an estoppel. So that during the negotiations, if you make a statement which is calculated to induce the other party to accept the settlement, now that's going to be a very contentious issue in itself, perhaps, but if that's what's done, then Justice Lander's saying, well, that will give rise to an estoppel. And thirdly, he says, apart from any concluded contract or estoppel, the party may be allowed to give evidence of what the other said if the exclusion of that evidence would be a cloak for perjury, blackmail, and this is a term I was looking for before, unambiguous impropriety, which is a term I think the English Court of Appeal used in the Unilever case. And his Honour also referred to the provisions of the Evidence Act which support the same conclusions in 131 subsection 2, paragraphs F and I. The other thing about the exceptions in the Evidence Act is that even if, this is an even broader exception I think, which is in subsection 131(2)(g), is that if the court in later proceedings might be misled by the facts if evidence was shut out of what went on in a negotiation, upon which a party then seeks to rely on the later proceeding, that evidence is allowed in. For example, let's suppose somebody unreasonably rejected, or it's alleged somebody unreasonably rejected an offer which would have mitigated their loss. There may be an action later on, for example, suing another party, perhaps suing a solicitor or barrister for negligence, and that part of the defence there is, oh, you didn't mitigate your loss when you could have, then obviously you can prove those negotiations in the settlement context or the mediation context to rebut the allegation of negligence or perhaps reduce the damages. Because to do otherwise, the court will be acting upon a misapprehension of the circumstances. Now I conclude with the desirability of settling, if one can. I think that just goes without saying, but in saying that, it's always difficult. There's a rhythm in the negotiations, I think, or a rhythm in a proceeding or a rhythm in a commercial dispute, which may not have gone to litigation yet, where settlement may be achieved or talked about, and picking that, I think, is always hard. It can arise in the most curious ways. Sometimes the clients who have been polarised by the dispute bump into each other socially, and lo and behold, the lawyers are talking on the Monday and trying to resolve the dispute. As I say, there's a rhythm in the negotiations or the conduct of the matter, I think we've all had the experience where you have a mediation and it's abysmally unsuccessful, but the matter subsequently settles because the parties are brought to the realisation that they're looking at a huge chasm called costs and risks of costs, and if they go any further, that's a real consideration to be brought to play. So all those sorts of things bear on the timing of your negotiations and your settlement.
I'd like to thank David on your behalf for his presentation this morning, but in particular for reducing his researches and experience into the paper which he has left us, which I think is a really valuable paper to include in our precedents file. So, David, thank you very much, and can I ask you to join with me in thanking David?